stops the interference that is happening. You only need one headset connected, and it kind of. Thank you so much.
Thank you.
I don't know. You know what I should do is put those sheets that differentiate in the middle. I just like stick them back in. I'll find it.
Okay.
We'll get to them.
Okay.
All right. So we're going to do what first? Yeah. All right. Jose Rosado. Rosario, excuse me.
I think so, yes. I'll let you know talk.
Yeah. If the attorney could put her name on the record, please.
Good afternoon, Your Honor. Yadira Rodriguez on behalf of Jose Luis Rosario.
All right, Mr. Rosario, you're here today because you're arrested on with the for two charges: possession of cocaine, possession of drug paraphernalia. I've reviewed the charging affidavit. I do find there's sufficient probable cause. As to the possession of cocaine, it's set bond the amount of $1,000, and on the possession of drug paraphernalia, $100. I'll reduce that bond. You are out on bond on a DUI. I assume that's what your attorney wants to be heard on.
I'm sorry, Your Honor. If they just put the headset, so I'm going to start the interpretation. He didn't have them on. Just give me a second.
Okay, you want me to redo that, or are you just going to go?
No, I have the notes. Just
Okay, great. Thanks. He does?
Right now? Sure. Courtney Daly on behalf of Public Defender.
Taylor May on behalf of the state.
Your Honor, can continue.
All righty. State, go ahead.
Would you like me to approach it?
No, that's all right. Just tell me what it is.
It's a Willis.
Is it it's a new charge, or?
Yeah.
Okay, so did they give him a ticket for Willis, but they didn't actually arrest him?
Willis with serious bodily injury.
Oh.
Would you like me to approach with the?
Yeah, I don't see that at all.
You can have that one.
See, I got them mixed up. It was too early in the process. All right, Mr. Rosario, you're also here on a driving while license suspended with serious bodily injury. I have read the charging affidavit, and I do find that there's driving while suspended. I don't see on the ticket. It doesn't indicate that there was any accident, or oh wait, there is something on there. So there's doesn't note in the charging affidavit that there was a wreck. That's what I was. Yeah, it's all no's. Well, it's for sure driving while suspended. Okay,
Yeah.
counsel.
Your Honor, may I be heard on that case ending on 6437, the one we were just talking about, the driving without it seems like he was charged with a felony on that one.
Yeah.
Under the statute, it requires for him to have 2 prior convictions. I was just hired last night. I haven't had a chance to look at the driving record, but talking to Mr. Rosario, it seems like he only has 1 DUI from 2016, which resulted in a conviction. He also has a driving without a license from 2016, but that one was no prost. So I don't think that he meets the 2 priors required for a felony charge, and I think that he should be charged in this one with a first-degree misdemeanor under 322.342B1, if I'm not mistaken.
Yeah, it's problematic. They actually, I think he put even the wrong statute in the sense that he put down that it was with serious bodily injury, and it shows it's just a regular traffic stop. So I think that it definitely should not be that. So I'll set bond in that in the amount of $250. I'll reduce the bond because I think it's just a regular Willis.
I believe the confusion was he had a Willis from 2019 that was adjudicated, and then he picked up a 20 civil traffic infraction in January of 2020. So I think that's what the officer.
Okay, so he saw 2, but it was really only 1. Okay, so I'll find probable cause for driving while suspended, but not for the felony. So that's just the 2. Then I'll step on the 250. What about as to he's out on bond on a DUI case, and he's out. Obviously, his license is suspended. He's still driving.
Yes, Your Honor. If I may just make a brief argument, or if you require for testimony to be entered before I make the argument, then I can do that as well.
Well, I don't know what testimony. I mean, if you want to present testimony from your client, go right ahead. I don't know what he can say or what he would say that would be helpful. It may be detrimental. I mean, the bottom line is he's out on bond for a DUI charge. The allegation is that he was driving, which he shouldn't have been doing, but that he was also driving and was in possession of cocaine. That's a bit of a problem. But go ahead. You can whatever argument you wish to make. Go ahead.
Well, Your Honor, he is the sole provider of a family of 3. He works in construction, and with the coronavirus and everything that's been going on, his finances have been affected greatly. He needs to be out there on work. Revoking his bond is just going to put more strain on him. So I would argue that he would. It would be disastrous for his family if his bond is revoked.
State.
Your Honor, I would just argue that he was on bond for a DUI, which his license was taken away, and as you stated before, he was driving and in possession of illegal narcotics and paraphernalia, which is obviously in violation of his bond conditions, as well as a new law violation. Therefore, I think it's reasonable to revoke his bond on the DUI charge.
Yeah, I think if it was just a driving license suspended, I'd be in a different situation. But I think the problem is that with him being allegedly in possession and I was looking at the driving pattern. I'm gonna revoke his bond. I will set a new bond of $5,000 though. So it's not a complete loss, but
Thank
okay.
you, Your Honor. That's all
right.
I have, Your Honor. May I be excused?
Yes, you may. Thank you much. Good luck.
Have a good day.
You too. Santos Chacon Pineda.
Body, Your Honor.
On it. Leobardo Alcazar Barragan.
Sí, Leobardo Alcázar Barragán.
All right, sir. You're here today because you're arrested on a charge of criminal mischief. I have read the charging affidavit, and I do find sufficient probable cause. Bond set in the amount of $500, and I will appoint a public defender to represent you on that charge.
Judge, this is Officer Davis of Pretrial Services.
Yes.
Mr. Leobardo, he does have an ICE detainer.
Leobardo Alcázar Barragán.
There's an ICE hold?
Yes, sir.
Okay. Well, we'll see if he can bond or whether they can, he's not going anywhere. So. Oh, well, sir, I've been
Leobardo Alcázar
informed that
Barragán.
yeah.
Mis papeles los tiene este que está aquí.
He's gonna,
I'm sorry. Can
Mis
I
papeles
have
los
one of the
tiene
correctional
el que tiene
officers?
el date 0523-2020. Sí.
what? Yeah.
Pero mi nombre no es este, mis datos.
Stop. Yeah. Listen to what she says.
I'm sorry, Your Honor. I'm trying to tell him to stop speaking because I
Yeah.
cannot understand him. That second microphone in front of him on the podium is causing interference. I can't I can't capture what he's saying. If the correctional officer could please move it.
There we go. Okay, she just turned it away, so hopefully that'll help. So it's moved away from his face. All right, Mr.
Que mis papeles los tienen.
Mr. Barragan, there is. Okay. All right, stop. Just a second. Let me just tell you something. Mr. Barragan, there is an ICE hold currently on you. So even though I've set a bond in this case, that immigration hold. Okay. That's not anything that I can deal with.
Y la troca que yo tenía la agency tiene el número de código de la clave de la agency con otra lotería.
I'm sorry, Your Honor. I can't hear him.
Don't worry about it.
Número que tiene
That's fine.
con mi fecha de nacimiento.
Let's go. Get out this way. Step up, baby. Get up. Get this shit.
Okay.
Found PD appointed.
Yes. That was before all of that.
I apologize, Your Honor. It was very
No,
difficult.
that's okay. No, it was not. Yeah, don't worry about it. Okay, I think that's it, right? Is that it for the Spanish?
That's it, Your Honor.
Thank you. Thank you very much, ma'am.
You're welcome, Your Honor. The interpreter will disconnect.
Alrighty. Okay, your name, ma'am?
Yes.
Your name?
Ashley Mesa.
What happened to Miss Glover?
Miss Glover refused, Your Honor.
All right, we'll reset her. Okay, Miss Mason, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find sufficient probable cause. And this occurred. This is not the one I was thinking of. Okay. Is there anyone here to speak on the case?
Yes, Your Honor. He's coming to the room.
All right. Who's in the box?
Say your name, sir.
Calvis Rodriguez.
All right, Mr. Rodriguez, raise your right hand, please. You solemnly swear the testimony not to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. And you are the alleged victim in this case, is that correct?
Allegedly, yes.
Okay. Do you have any fear of Miss Mason?
No, sir.
So you understand that I could place conditions on her that would not allow her to have contact with you and to not return to. Do you guys live together?
Yes, sir. We have two kids together, too.
I could also require that she not come home to where you are and that she have a separate residence. You understand that?
I would like for that not to happen, sir.
Okay. Well, that was going to be my next question. You do understand I could do that to protect you, but if you want to, I can allow her to come home. Is that what you want?
Yes, sir.
You don't have any fear or any thinking that she may attempt to batter you?
No, sir.
Okay. All right. She doesn't qualify for PTR, I see. Or, well, actually, has that been updated at all or no?
No, sir. She hasn't been interviewed.
All right. What I'll do is I'll set a bond amount of $500. You're not to have any hostile contact with Mr. Rodriguez. Okay. That means you can go home and you can have contact with him, but you can't be hostile. You can't raise your voice. Can't take a swing out of anything. All right. Nothing at all. Okay.
There was some alcohol involved that I won't be.
Well, I got the flavor of that from the charging affidavit, and maybe that's something else to think about while you're on bond. No alcohol, no drugs, no guns, no weapons while you're on bond. So in the short term, you're not going to be drinking, so this hopefully won't be an issue.
Certainly.
All right, and I will say $500 bond or PTR conditions. If they interview and you qualify for pretrial release, I'll allow you to be released without a bond, but they're going to have to talk to you about that first. Okay. Otherwise, there's a $500 bond set, so you can for sure bond out if you just want to go that way. Okay.
Okay.
Thank you, Your Honor.
Thank you, Mr. Rodriguez. Your name, sir?
Stephen Johnson.
Mr. Johnson, you're here today because you're arrested on charge of possession of cocaine and possession of drug a prescription drug without the proper prescription. I have reviewed the charging affidavit. I do find sufficient probable cause for those. There's a bond amount of $1,000 on the possession of cocaine. I'll reduce the current bond on the possession of the prescription drug to $100, and I'll appoint a public defender to represent you on those cases.
He has an additional.
Oh, he has another one. There's also the possession of drug paraphernalia. I set a bond of $100 on that as well. Okay. Thank you. Your name, ma'am? Your name?
Yes. Sorry. I'm not used to the video chat thing. Sorry.
Okay. Yeah. Well, that's what we do now. What's your name?
Lena Calderon.
All right, Ms. Calderon, you were arrested on a charge of contributing to the delinquency of a minor. I don't know how we get there with this.
That's what.
Yeah. I realized there was a search warrant and that there was drugs and firearm found there, but I don't.
According to statute, there has to be some sort of command act or between.
Yeah.
Your Honor, can I have a 24-hour reset to reach out to my officer?
Yeah. Okay. So what's going to happen, Ms. Calderon, is I'll set bond at $500, which is currently at. I'll appoint a public defender to represent you. The state, though, is going to have 24 hours to develop more information to flesh out this charge. And we'll bring you, if you don't bond out, we'll bring you back tomorrow morning or around this time. And if they have not developed enough information for me to find probable cause, then I will release you without a bond. Okay. But if you decide you want to get out of jail today and just post the bond, you can do that as well. Either way will work out. But if you can't post the bond, then you'll have another shot at it tomorrow if the state can't come up with the proper information. Okay?
Yes.
And I will appoint a public defender to represent you too.
Thank you.
Alrighty. Well, the kid that was with her, he ain't getting out. That was one of the kids from this morning. Your name, sir?
Samuel Melvin Smith.
What happened to Miss LaFaro? Didn't want to come?
Mental health, Your Honor.
Mental health again. Reset. Let me see. PD want to waive her appearance, Miss LaFaro? Trespass and resisting without.
Yes, Your Honor.
All right, we'll waive her appearance. I'll go ahead and find probable cause set bond 500 and 100 as stay the bonds as they were. All right. Your name was Samuel Smith, is that right?
Yeah.
All right, Mr. Smith. You're here because you're arrested on 2 new charges of exposure of sexual organs. I do find sufficient probable cause on those. Set bond of $500 on each one of those counts. You are out on bond on a ROR on another charge of exposure of sexual organs. State?
Your Honor, given the repeated nature of the repeated nature of his actions. That's what I was going for. We'd ask that the bond be revoked on the other exposure case.
Obviously, this is in the middle of some competency evaluations, but nothing's happened on it yet, I assume?
I don't think anything's happened. I looked it up, and all that's happened is that information's been filed in the new case.
Yeah. All right, I'm going to revoke the other bond. Set no bond on that. So on the other cases you were out on, the case you're out on bond on, I revoked that bond. There will be no bond on that. A public defender's been appointed, and they'll speak with you. Thank you. Yeah, 500 on the new case. All right, Mr. Torres is back. He didn't bond out. Was the state able to develop anything to show that he was operating a motor vehicle or that it was actual physical control?
No, Your Honor. I did reach out to the officer, but he did not get a
all right.
amended affidavit to me. So.
All right, what I'll do is then I'll release you on your own recognizance, Mr. Torres. So that means that you don't have to post a bond. You'll be released today on this charge. It doesn't mean the case is dropped. There will be a case if the state decides to file it and go forward with it. So you need to keep in contact. I did appoint a public defender yesterday, so you can contact them and they can tell you about court dates and stuff, okay?
All right.
If there's no bond or anything, you'll be released at some point today.
Okay.
No PC, yeah. All right, now we're into the misdemeanor and traffic VOPs. Your name, sir?
Daniel Leon Vera.
Okay, here we go. Just a second.
Your Honor, Eric Benson representing Mr. Leon.
I thought I recognized that person underneath that mask.
Yes, sir.
I wasn't positive, but let me dig down and find his paperwork. Okay, there it is. Not too bad. All right, Mr. Leon Vera, you're here today because you're arrested on a charge of child abuse. Okay, all right. I do recall that one. I do have find sufficient probable cause. Mr. Benson, did you want to be heard as to bond?
Yes, Your Honor. Mr. Rivera has been a resident of the state of Florida for several years. He also has been steadily employed. He is currently on a hiatus because of he works at Olive Garden, so he's currently at home. We would ask the court set either ROR or very low bond, $500. Additionally, Your Honor, we are involved in current litigation in the domestic arena regarding this child.
I got the feeling there was something that was involved.
Yes, sir.
Okay, State. Let me take a look at this. So he has no priors at all. Is he not? Is not eligible for PTR because of the nature of the offense? Is that right?
Yes, Your Honor.
All right. I'll release him with PTR conditions.
Hold on, do you have a victim here?
Oh, we do?
Yes.
Okay. Who do we have in the box?
Amy Anderson.
All right, raise your right hand, please. Solemnly swear testimony not to give you the truth, the whole truth, and nothing but the truth to help you God.
Yes.
All right. And how are you related to this?
The victim is my son, our son.
Okay. What did you want to tell me?
I came just to say that I am fearful of him being around our son again, because this isn't the first time that it has happened. So I'm fearful for him to be around our son.
Okay. All right. So if he bonds out or released, then you would rather that he not have any contact at the short term from this case. Is that right?
Yes, I would prefer no contact.
Okay. All right. Anything else that you wanted to say?
No, Your Honor.
All right. I will give him a PTR conditions release. On the short term, you're not to have any contact with your son. Now, if there's something that happens in the domestic case for visitation, or because I assume there's going to be something that comes from this in the domestic case, but on the short term, the condition of bond will be no contact from this case. However, if they something subsequent where the domestic judge is aware of this and says that visitation is okay, or there's supervised visitation or whatever they decide, then I don't have a problem with the bond being modified to allow that condition for this case as well, if that makes sense.
Yes, Your Honor.
I'll let them drive the bus on that because they're certainly going to have more information and a lot more, they'll know what's going on more than what's just based on this 2 pages, okay?
Your Honor,
all right, no drugs, no alcohol, no guns, no weapons, sir.
Your Honor, could we address one issue?
Sure.
Is that while this is one of no physical contact, would it be permitted for Mr. Leon to have telephonic or Zoom contact with the child? Because I think it's important to continue communication with the child through electronic means.
May I say anything, Your Honor?
Sure.
Currently, our son is fearful and crying at the mention of his father, so I don't think it would be beneficial for him to see his father right now, as every time he walks around, someone asks him about the marks on his face, and his response is, "My daddy hit me." So I think emotionally it would not be beneficial for our son to be able to speak to his father right now.
State.
Your Honor, I'm also in agreement with the victim's mother that the normal condition is no contact with the victim or no hostile contact. Since no contact is preferable in what you are going to order, I agree with the victim that it would not be beneficial to the child to have Zoom or telephonic contact. Because of the age of the child, I think I'm going to agree with the state in this situation on the short term. If in fact the domestic judge feels that he's heard enough, or he or she has heard enough and recognizes that it's okay, then they will. But I think at this point, I'm going to go ahead with the no contact. And also corrections, could you have them sign a no contact order on that as well, please? Yes. Because we didn't have one. Thank you.
Your Honor, you said you were going to release him on pretrial?
Yeah, with pretrial conditions, I mean, it sounds like he would qualify for that other than the fact that it's the charge. So, but that way you can keep a good control of him.
Okay.
Okay? Thank you, guys.
Your Honor, good to see you.
Good to see you. Well, what I got to see of you.
There you go.
There it is. Okay. Take care.
Thanks, sir.
Your name, sir?
Eugene Taylor.
All right, Mr. Taylor, you're here today because you're arrested on a violation of probation warrant for driving under the influence from Division 83. There's a bond in the amount of $5,000 on that, and I will appoint a public defender to represent you on that violation of probation.
Thank you.
Thank you. That's it. Your name, sir?
Jack Rodriguez Melendez.
Sir, you're here today because you're arrested on 3 charges. First of all, battery by strangulation, domestic violence, tampering with a witness to hinder communication to law enforcement, and battery, simple battery, domestic violence. This was based on an arrest warrant, and I do find that there was sufficient probable cause. Now, as to those these charges, I think that the alleged victim is Deborah Rogers. Is that right?
Yes, sir.
I think that she's
in jail.
She's in jail, and I think that was the one that the bonds got revoked on, wasn't it? So she's in jail. She's not going to be out. You guys were living together. Is that correct?
Yes, sir.
Okay. But she's in jail and is not going to be getting out on the short. I know for sure because I revoked her bonds yesterday on the stuff she was out on bond for. Can you can obviously return back to your place if she's not there. Okay. Now, I know she's not going to be there at least, for a little while because she had about 5 bonds that I revoked and they're all no bonds. So it'll take a little while if she's going to go to the judge and ask that there be bonds reinstated. So what I'll do is I'll just allow you to return. As to the battery by strangulation, I'll set bond amount of $1,000. The tampering will be $100, and the battery domestic violence will be also $100. And or actually, I'm going to make that one $250. And no contact with Deborah Rogers, okay? No contact at all is allowed. You can return to your home since she's not going to be there. No drugs, no weapons, no guns, no alcohol, okay?
Okay, appreciate it.
Alrighty. And I'll appoint a public defender to represent you.
Thank you.
Your name, sir?
Hey, how you doing?
Your name?
Shane Bryan.
All right, Mr. Bryan, you're here today because you're arrested on a charge of aggravated assault with a deadly weapon and domestic violence. And I have read the charging affidavit. They find sufficient probable cause. This happened at a hotel, is that right?
Yes, sir.
Do you have a place to go and live other than that hotel?
Well, we're here from South Carolina. We actually live in South Carolina, and we were here just letting her daughter see her father for the weekend.
Yeah. Okay.
And we went to a restaurant, and she did.
Okay, your attorney's probably gonna get it. You don't want to talk too much about the facts of the case. The key is you live in South Carolina, and the alleged victim is your girlfriend. Is that right?
Yes.
And does she live in South Carolina with you?
Yes, sir.
All right. Did she return to South Carolina, if you know?
I'm not sure.
All right. Well, because I haven't heard from her, I can't allow you to have contact with her or to go back to where she lives. So I don't know where you're going to go, but you can't go there. Okay? Does that make sense?
Yes.
All right. I will set bond in your case in the amount of $750. Going to require you have no contact with, and let me make sure I get the name right here.
Candace.
Yes. With Candace. Now that could change if she Candace Carpenter. If she contacts the state attorney's office and then they agree that no hostile contact or contact's okay, then that would be fine. You're also not to return to, is that the Ridge Lane Drive? Is that a Ridge Line Drive? That's your address?
Yes, that's in South Carolina.
All right, you're not to return there while she is living there. I mean, if she leaves and moves somewhere else, then I wouldn't have a problem with you going there. But on the short term, you can't go there in South Carolina. Yeah, you can go there one time. Now, it's a little more complicated because you're going to be in South Carolina, but you can go back to your home one time with law enforcement to get pick up personal items. All right.
Okay.
I don't know if I'm sure they probably have a similar system that they have here. You just contact law enforcement. They'll go with you. Make sure you're only picking up personal items and make sure nothing happens while you're there. Okay. Any questions?
No. And you said the bail is how much?
$750.
So is that the bond or the bail? Is that, I don't know.
That's the bond amount. That's the bond amount. You talk to the bondsman. That's whatever you can work out with them. Usually it's, 10%, but
okay.
It'd probably be $100. I think it's usually a minimum of 100.
Okay, thank you so much. I appreciate it.
Yeah, well, that's true. You're being out of state. It's probably going to be more a higher percentage.
Yeah.
Okay. Your name, ma'am?
Ramona Michelle Burrows.
Ms. Burrows, you're here today because you're arrested on a charge of aggravated battery, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. Is Mr. Ware present?
No, Your Honor.
No.
All right. Do you live with Mr. Ware?
Yes,
All right, is that at the 4300 Colony Way address?
Yes.
All right, do you have somewhere else to go that you can go live without going to that address and without living with Mr. Ware?
Not really.
Friends, family?
Yeah, I'll find
No friends?
Somewhere. I'll find somewhere.
All right. Well, because you're going to have to. You can't go back and stay there with him, at least on the short term. Now, if he contacts the attorney's office and says he wants to have contact with you, then that's a whole different thing. But, all right, I'll set bond the amount of $500. Okay.
Your Honor, she does qualify for pretrial release.
Oh, she does? Okay. I
Yeah,
didn't
her
have that. I
information
guess
was updated.
that was an update. All right, great. Then what it'll be is I'll release you with pretrial release conditions. No bond is required. Okay. But while you're out there, you're not to have any possess any guns or weapons or any alcohol or drugs, not to ingest any of those. And you're not to have any contact with Carl Ware, all right? And also not to return to 4300 Colony Way. Now, you can go back there one time with law enforcement to pick up any personal items that you may need. Okay? But you got to contact the sheriff or the local police department, and they'll send someone out to go with you. Okay? Don't go by yourself because that's a violation. Okay? All right.
Okay, I'm gonna need help. I had to find this. Froze up. I can't do anything right now. Can I get some water? I need some water. When you get downstairs, you get some. I pass out with my anxiety.
Oh. This guy's falling. He's about to fall out.
Sit down.
Oh, that's it. Yep.
Open that door and show one in the come here. Yeah.
Excuse me.
Come on, Miss. You think you need medical? Come on now. Come on. Grab a wheelchair.
He's out.
You all right?
She said she got anxiety.
Can I get some water?
Well, we got to take out there to get the water. Is she bleeding out? No. She sorry. She never sorry. Hold on to this moment. You gonna go home? It's okay. It's over right now. Let's get a moment now. Okay? Just try to sign, and then we're gonna take you to get some water. So you get some water.
Sign. Medical situation.
That's good for us. Thank you. Make it to the suit to get you some water. Okay. You sure? Okay. Okay, well, head on. Here go the wheelchair. We're gonna put you in the wheelchair, okay? All right. Step up a little so you can get in the wheelchair. All right, stand up like you do. Go. Hold your feet up. So you can really got.
Good work. Way to go, you guys. All right. Your name, sir?
Will Andre Davis, Jr.
All right, Mr. Davis, you're here today because you're arrested on a battery by strangulation and domestic violence charge. I reviewed the charging affidavit, and I do find sufficient probable cause. Now, I see that this happened at a hotel. You live here in town?
Yes, sir.
We have a victim.
And do you live? There's, what's that?
We have a victim.
Oh, she's here. Okay, great. And do you live with Miss Horta?
Yes.
Okay. Who's in the box? Is that Miss Horta?
Yes, sir.
All right, ma'am, raise your right hand, please. Solemnly swear the testimony I have to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. You are the alleged victim in this case, is that right?
Yes, sir.
What did you want to tell me?
That I don't fear for him at all. We do live together. I do want to remain in contact. I just didn't want to go any more further than what it's already gone.
All right. You understand that I could give him a condition that he not return to where you guys live, that he not have any contact with you to keep him away from you if that's what you wish.
I do not wish that, sir.
All right. And because that's the only way I can protect you. You do get that, right?
I do understand.
Okay. All right. Well, what I'll do is I'll set bond the amount of $500. And I'll have condition that you not have any hostile contact with Miss Horta. Are you going to have contact with her? Don't raise your voice. Don't raise your hand to her. Nothing like that. No hostile contact. You understand that, Miss Horta? That's what the condition's going to be.
Yes, sir.
So if he gets hostile with you, then you can call law enforcement, and that's a violation. He'll be back in jail. All right.
Okay.
You're not to have any guns or weapons, any alcohol or drugs while you're on bond. All right. And you can return back to the house because she says it's okay. Okay? I'll appoint a public defender to represent you. Good luck. Your name, sir?
My first name is Raed. My middle name is Ode. My last name is Mwala.
All right, sir, you're here today on a number of charges. I have reviewed the charging affidavit, and I do find sufficient probable cause. The charges are as follows: burglary with an assault or battery, kidnapping, false imprisonment, aggravated battery with a deadly weapon. Which one is twice?
I'm sorry?
That was the number. That's the count. Count 1, count 2, count 3, count 4.
Oh, I'm sorry.
Oh, yeah. Okay. Yeah. On the aggravated battery, there's 2 counts of that. There's 2 counts of simple battery. There's an aggravated assault with intent to commit a felony. There's another count of battery domestic violence. There's an obstruction of justice, which is tampering with evidence, and a criminal mischief charge. I have reviewed the charging affidavit.
Okay.
And there's one more, and there was a resisting that I actually was wondering about. Okay.
We also have a victim, Your Honor.
Okay. Who's in the box?
This is Manel.
All right. What's your first name?
Manel, first name.
All right. Raise your right hand, please. Solemnly swear the testimony you have to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I swear I'm gonna.
Me?
Okay. No. All right. Yeah.
Please don't talk about the facts, sir. Please.
Yeah. Don't talk about your case yet. The public defender is losing her mind over here. Just be quiet for a second. All right, ma'am. What did you want to tell me? In the box.
Okay.
Yes.
I don't feel I'm saved if you release him. Because like yesterday what's happened, he just he grabbed me and he tried to kill me there, and I'm scared to be in my apartment if you release him. I want something to protect me and my kids.
Okay. Did the state have any questions for her?
Yes, Your Honor. Good morning. My name is Sarah May. I'm from the State Attorney's Office, and I have a few questions for you real fast.
Yes.
Can you please tell me the relationship you have with the defendant? Are you guys married, and for how long?
We separated, and now we're getting divorced.
Okay. And has anything similar to this ever happened in the past?
Yes.
And how many times would you estimate?
This is the 3rd time he tried
okay,
to hit me like a crazy. Will be any minute when he's doing this. Yesterday, he come to my house, he grabbed me, he slapped me, my eyes, my legs, I can't walk.
Yes, ma'am. Okay, so things have happened in the past.
Yeah, that's what happened the best. He just the same what he
Okay.
did yesterday, and he bite my fingers. He was gonna cut my fingers.
And you previously said that you are afraid of the defendant?
Yeah.
So would you like to have contact with him, or would you not like to have contact with him?
I don't want to contact with him. I don't want to see him. I don't want him around my kids in my house. I don't feel safe to be around me.
So do you believe that he would cause harm to your children if he were allowed back into the
He didn't harm
residence?
my children, but he harmed me yesterday because I don't know what's going on with his brain. Is something wrong with this guy? I'm scared to be there because he lived with his sister, same neighborhood.
Okay, and the last question I have for you is, did any of these other prior incidences or this incident ever happen in front of your children?
yesterday is not a friend of my children because my children was sleeping, but the first time, yes. And my kids keep looking at me in my eyes yesterday, and they told me they don't want to see him. They don't want him to come to the house. He's not living with me, but he lived with his sister.
Okay. Thank you, ma'am. That's all I have for you. The judge might have some more questions, though.
I do need to have you spell your first and last name for the record for the court reporter because they're having difficulties.
First
If you could.
I'm Manal, last name Bahar.
And how do you spell your first name?
I'm A-N-A-L.
And then last name is B-A-H-A-L. Is that right?
Yes, right.
Okay, great. All right. Okay, State, do you wish to be heard for as to bond on these?
Oh, okay. Not at this time, Your Honor.
Okay. As I said, I do find sufficient probable cause on all of these. As to the burglary with a battery, I'll set bond the amount of $15,000. On the kidnapping, count 2, I'll set bond the amount of $15,000. The aggravated battery with a deadly weapon would be there's 2 counts of that. It would be $5,000 and $5,000. Battery, the 2 counts of battery would be $100 apiece. The aggravated assault with intent to commit a felony would be $500. Battery, $100. There's 1 count of that. Obstructing or tampering, $100. Damage, criminal mischief, $100, and the resisting officer without violence, $100. And I will appoint a public defender to represent you. Excuse me. I'm sorry. I got wrapped up in the numbers. Yeah, you're not to have any contact at all with, if you do bond out with Manal Bahal, you're not to return to 1695 Lee Road or to go anywhere near there. You're not to have any contact with any of your children at this point in time as well. Okay?
Yes, sir.
No guns, no alcohol, no drugs, no weapons.
Yes, sir.
Okay?
Yes, sir.
All right. All righty. All right, your name, ma'am?
Hello,
Your name?
Teresa Baker.
All right, Ms. Baker, you're here today because you were arrested on charge of battery, domestic violence. I've reviewed the charging affidavit, and I do find sufficient probable cause. Is there anyone here?
No, Your
Yep.
Honor.
Okay. All right. And Mr. Perdue, the alleged victim of the case, do you live with him?
Yes, sir.
Do you have another place to go in case if you do get released or bond out?
Yes, sir.
Where can you go?
My mom's house.
Okay. All right. You do qualify for PTR, so I'm going to release you with pretrial release conditions, so there won't be a bond required. Okay, but you do have to live up to the conditions of PTR.
Okay.
You're not to have any guns or weapons, no drugs or alcohol. All right, and you're not to have any contact at this point with Mr. Perdue at all. Now, you're the 5181 Cinder Lane Parkway. Did you live there with Mr. Perdue?
He lived with me. That's my home.
Okay, that address, you cannot return to that except for one time in the short term. You can go back there one time to get some personal items. Okay. Now, if he moves out, then they would consider changing that bond so you can allow you to go back there. But for right now, you can only go there once with law enforcement to get your personal items. Okay.
Okay.
All right. Your name, ma'am?
Paulette Brigade.
Ms. Brigade, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find that there's sufficient probable cause. Is there anyone here for, is Roberto here?
No, Your Honor.
All right. Did you live with Roberto at 1809 Harrell Road? Is that right?
1811 Harrow Road. Yes.
That's interesting. Yeah, address wrong. Okay. Do you have another place that you could go and live? Friend, family, somewhere?
Yeah.
Okay. You do qualify for pretrial release. I'm going to release you with PTR conditions, so there won't be a bond required. Okay, you'll be released, but you have to live up to the conditions of that pretrial release. And you're not to have any contact right now with your husband, with Roberto, until potentially that could be modified at some point. But no contact with him at all. No guns, no drugs, no alcohol, and no weapons. You can't return to your home with him, all right, except for one time you can go back there with law enforcement they'll go along with you so you can get your personal items. All right, I will appoint a public defender. You can contact the public defender's office, and they can potentially look into modifying that if Roberto wants that to happen. Okay?
Okay, thank you.
All righty, thank you. Your name, sir?
We go. Oh, which side?
Doesn't matter. Which one or the other, just get in front of one of them, yeah. There you go.
Rico Bird.
All right, Mr. Bird, you're here today because you were arrested on a charge of battery, domestic violence. I have read the charging affidavit. I do find that there's sufficient probable cause on that case. Do you live with Miss Balsis?
Yes.
All right, so you guys live together at that Windtree Lane address, is that right?
Yeah, that's correct.
You have another place that you can go to live right now?
Yes.
Okay. You do qualify for pretrial release, so I'm going to release you with pretrial release conditions. You're not going to have to pay a bond, but you do have to live up to the conditions of that pretrial release, okay? No guns, no alcohol, no drugs, no weapons. You're not to have any contact with Miss Balsis right now, all right? You can't have contact with her. She can contact the state attorney's office and change that if she wishes.
Okay.
Now, you're also not to return to the 156 Windtree Lane address. You can go back there only one time, and that's with law enforcement so that you can go get your personal items, okay? But you can't go back by yourself. You need to call law enforcement to go with you. All right, thank you. Your name, sir?
Robert Anthony Caldwell.
All right, Mr. Caldwell, you're here today because you're arrested on a charge of battery, domestic violence. I have reviewed the charging affidavit. I do find sufficient probable cause. Now, I see that this happened at a hotel, and the alleged victim is Michelle Caldwell. Do you live with Miss Caldwell?
Yes.
You do, and that's and what is that? Is that what address do you live with her?
That's the 7900 South Orange Blossom Trail.
Oh, okay, so that is the correct address. Oh, so you were living together in the hotel?
Yes.
Okay. Is she still in that hotel? Do you know?
I'm not sure.
All right. Well, you do qualify for pretrial release as well. I'm going to release you without a bond. I'm just going to release you with pretrial release conditions. So there won't be a bond required, but you will have to actually live up to the conditions of that program. You understand that? You're not to have any guns or weapons, any drugs or alcohol while you're on pretrial release, and you're not to have any contact with Michelle Caldwell. None at this point. All right. And you're not to return to the hotel room that you were living with in her. I would suggest you go to a different hotel. Don't return to that hotel. Okay. If you do need to go, if you have personal items that are at that hotel, you can go back there one time if she's still there with law enforcement, and they'll escort you there and go in with you to make sure nothing happens, and also to make sure you only take your items. Okay.
I have a question.
Sure.
I'm an over-the-road truck driver as a profession. Would this pretrial release affect that?
You'll have to talk to them about that. It very well may, but they'll talk to you about that. Okay.
Okay. Thank
I can set a bond instead if you want me to do that. If you'd rather just have a bond, I'll tell you what I'll do. I'll set bond in the amount of $500 or pretrial release. You can talk to pretrial release. If they tell you then it doesn't sound like it's going to work for you, you can just bond out and not have to worry about that. Although all the other conditions are there. You can't have contact with her. You can't return to that place unless you go with law enforcement. All that stuff still will be in place if you go on a bond or PTR. Okay?
I'll do the PTR.
Okay. All righty. Good luck.
All right. Thank you.
Yeah. Your name, sir?
Robert Cole.
Mr. Cole, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find sufficient probable cause in that case. Now, Ms. Cole, Andrea Cole, is the alleged victim in the case. Is that your wife?
Yes.
And you live together, I assume?
Yes.
All right. Do you have a place to go live other than the Avlay Court where she is?
No.
No friends, no family or anything?
I got a friend, but I can't live with him.
Well, the problem is you can't go live with her right now.
Okay.
If I release you or give you a condition of release, you can't have any contact with her until she says it's okay. And she's not here to do that, so I can't allow it. Okay.
Okay.
So you're gonna have to find somewhere. Okay.
I'll just go back to
All
New
right.
York.
All right, you do qualify for pretrial release. I'll release you with pretrial release conditions. So that means there's no bond required, but you do have to live up to the program. All right, there's some things you have to do. The pretrial release conditions. I'm going to require you to not have any drugs or alcohol, no guns or weapons while you're on that pretrial release. You're not to have any contact with Andrea Cole, the alleged victim in the case, and you're not to return to 1460 Avlay Court or Circle, in Orlando while you're on pretrial release. You can return there one time with law enforcement, be escorted by law enforcement, so that they're there to make sure that you don't cause any problems, and that you take your items with you. Okay.
Okay.
All righty. Good luck. Your name, ma'am?
Catherine Dominguez.
Ms. Dominguez, you're here today because you were arrested on 2 charges of battery, domestic violence. I have read the charging affidavit, and I do find sufficient probable cause. Do you live with Jorge at the Casa del Rey Circle address?
No, sir.
You don't? Okay. Where do you live?
4254 South Kirkman.
All right. And where does he live? Does he live at that address?
Yes, sir.
Okay, great. All right. Well, I'll set bond in the amount of $250 on each count. And require you have no contact with the alleged victim in the case, Mr. Gill, Jorge Gill, and you're not to return to the Casa del Rey Circle. Do you have anything at that address that you need? Is there any personal items or anything that you may need to go and pick up?
No.
All right, good. So just no return there at all. No guns, no weapons, no drugs, no alcohol, and again, no contact with him. I'll take no action on the DUI bond. All right. Thank you. Appoint a public defender to represent her. Your name, sir?
Hello. How you doing?
I'm good. How about yourself?
Doing all right.
All right. And your last name?
Edwards.
All right, Mr. Edwards, you're here today because you're arrested on a battery domestic violence charge. I have read the charging affidavit, and I do find sufficient probable cause on that case. Now, do you live with Miss Light?
She's here, Your Honor.
Oh, she is. Okay. Is that Miss Light's in the box? Is that right?
Yes.
Raise your right hand, please, Miss Light. Solemnly swear the testimony I have to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right. What did you want to tell me?
I would like to keep contact. And I would like for him to be able to get his things and come home.
All right. Well, you understand that I could require that he not live with you and that he not have any contact with you at all, or even no hostile contact. It's the only way I can protect you. You understand that, right?
Yes.
But you don't want me to do that.
Yes.
You're not afraid of him at all?
No.
Think that if he comes home, it's going to be fine. He's not going to cause any problems for you. Is that right?
Yes.
Okay. You do qualify for pretrial release. I'll release you on PTR conditions. That means there won't be a bond required, but you do have to live up to the conditions of the program, and they'll explain that to you. You're not to have any guns, no weapons, no drugs, no alcohol while you're on pretrial release. You're not to have any hostile contact with Miss Lyle. What I'll do is it's Miss Light, excuse me. You can't raise your voice to her. You can't raise a hand to her, nothing, okay? No hostile contact. But I will allow you to have contact, and I'll let you to allow you to return back home again, okay?
Yes, sir.
All right, thank you. Thank you, Miss Light.
Thank you. Have a good day.
Angel Glover, Your Honor, refuse.
Good in.
Angel Glover, refuse.
I don't know. Yeah, the next one I have is Lacia Betancourt.
Mental health, Your Honor.
Mental health. What is this? I'll reset it. Yep. All right, and then the next one I had was Tariq Nakirti.
Nakirti, yes, sir.
That's you.
Yes, sir.
All right. Sir, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find sufficient probable cause. Small, but it's there. Do you live with?
That's my wife, sir.
Christina Meyer. Okay, that's your wife. Is she here today? She's not there? No one in the box? All right. Do you have another place to go other than Calabria Court?
No, sir.
No friends, no nothing?
No, sir.
Because you're not going to be able to go back there. If she's there, you can't go there. If she's
Okay.
not here to tell me today, I'm going to have to require you to have no contact with her.
Would there be any way that you guys could call her, or I could have her write a letter? I mean, I honestly never touched my wife. She was just angry with me. I cheated. She said,
Go ahead.
basically,
Please
I
stop
did.
talking.
Yeah. Dude, just stop for a second. Your attorney is not happy. Don't speak. The public defender doesn't want you to talk because you may say something that's going to damage your case. So there's also a state
I
attorney
did
here
nothing.
writing everything down. Okay. Well, then I will set bond in the amount of $500. I'm going to a condition of that bond will be that you not return to 8010 Calabria Court, and that you have no contact with Christina Meyer. Now, she can contact the state attorney's office and ask that be changed, but that's not going to happen right away. And if you bond out today, it's certainly not going to happen before tomorrow. So you're going to have a place other than the Calabria Court address to go to. But again, no contact with her and no return to there. You can go back there one time with a law enforcement escort, so you can pick up your personal items if you need to pick up anything at all. But only one time, and then again, have no contact. Other condition of bond be that you have no drugs, no alcohol, no weapons, or no guns. I'm going to take no action on your possession of controlled substance bond, but and that's set for arraignment on June 18th. But you got to find somewhere to go. All right.
Okay. Now, let me ask you something, Your Honor. Is there any way I could get that bond reduced? Man, it's been tough times right now.
No, I'll tell you. You're lucky that I didn't revoke your other bond and keep you on no bond. So you might want to just take that and move along.
Yes, sir.
Okay. All right. Good luck.
Thank you.
Your name, ma'am?
Good evening. Hi.
Hi. Your name?
Imani.
Last name?
Sharban.
All right, ma'am. You're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit. Now, I know this was your mother. Is that right? The alleged victim?
Yes.
Do you live with her?
Yeah.
She's here?
Yes.
All right. All right. In the box, what your name, please?
Denise Curlew.
All right, ma'am. Raise your right hand. Solemnly swear testimony to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. What did you want to tell me?
I don't want her around me. I don't want any kind of contact. I don't want her returning to the house that I live in with my mother.
Mommy.
And I know she has to contact me because her 5-year-old daughter stays in the house with myself and my mother and her. So I know there has to be contact for her and her daughter, but I am fearful of what she will do to myself and to my mother's home. I'm fearful.
Your Honor, can I please say something?
Please don't.
Okay.
If it has anything to do with what you did or didn't or allegedly did, then you shouldn't, because it may damage your case.
No, it
All
doesn't
right.
have anything to do.
Okay. Go ahead. We'll be ready to stop you quickly. Go ahead. What did you want to tell me?
I just wanted to apologize to my mom. Like, I just reacted out of emotion.
Not accepted. I'm sorry, Your Honor.
Please
I'm
don't
sorry.
don't apologize. Don't talk about the facts.
Yeah. Okay. Well, you do qualify for pretrial release, so I'll release you with pretrial release conditions. So that means there's not a bond. But you can't go back to the La Havre Boulevard address. You're going to have a friend or another relative who's willing to take you in. So you can't go back there. I'll allow you to go there one time with law enforcement so that you can pick up any personal item, clothing, toiletries, things such as that. But you can't go back there to live.
Excuse me, Your Honor.
So, yeah.
Go ahead. When that one time with law enforcement, is that going to be arranged with me, or she just can show up? Can she just make that without letting me know she's going to come there?
Well, generally they're going to contact you. Law enforcement generally, she's got to contact them first, and it's not really easy to do. So they will let you know that they're on the way. But they'll be there to escort her to make sure that nothing, she doesn't take stuff she shouldn't, and that there's no problem. Now, you indicated that you're taking care of her child and that you would have no problem with
Just
her
phone
contacting.
calls. Just phone calls.
Okay, all right.
Can I ask a question, Your Honor?
How about you guys let me talk for a second?
Okay.
How about that? Since I'm the one who can make the determination. You indicated that you thought that a phone call to talk to her about the child would be okay. Is that right?
Yes.
All right. So what I will do is I will say that there's no hostile contact between Ms. Charbon and yourself. Okay, so she can call you to discuss the child, but you're not to talk about the case or anything like that. Okay, you understand that, Ms. Charbon? So you can make phone calls to her.
Okay.
And you can have contact, but not hostile contact. But you're not allowed to go back there, and you can't have physical contact with her. You can't go see her.
Okay. I can't see my daughter.
Who has custody?
Me. I do. Don't do that, mommy.
Well, if it's your child and you have custody,
Once she's out, she should be able to.
yeah. If she bonds out, then the child can stay with her.
Thank you.
There's no. I mean, there's not any. If there's no DCF or anything involved, then there's no order. It's her child. So.
Can I ask a question, Your Honor?
Yep. Sure.
Okay. Yes, it's her child. That child is with me majority of the time. How do I ensure that that child has someone really safe to be? Because she really does, I don't know where she's gonna go. So how do I know that that child won't be at a bus stop at night? How do I ensure that safety?
Well,
Or
unfortunately,
is that nothing? I can't ensure that where she's saying she's staying is really where she's staying. And that child is gonna be safe.
But unfortunately, that's just the nature of the way it is. I mean, in the sense of if she hadn't been arrested on this and she decided to leave her house and she had her daughter with you, I think you probably would be in the same situation. It's unfortunate, and I would expect that somebody who's a mother would do their best for their child and make sure that that's not the case. And again, I can't order anyone to do anything in this situation. I don't have any jurisdiction over the child or anything. I'm just telling you that if in fact she's released and she has custody of the child, at some point it's her child and she can take care of the child. It has nothing to do with the conditions of my release. It doesn't have anything to do with this case. The child is not involved in the case, and so that's really more of a civil matter, and it's not something I can take part in. But I'm just telling you that based upon what I've heard, she has the custody of the child, and the child can be with her. Now, if you have fear for the child and there's some kind of issue with her parenting, that's another issue, and that's between you and her.
Okay.
And you can do whatever needs to be done. Okay.
Okay.
All right, everybody. Yeah, no drug, no alcohol, no guns, no weapons. Usual PTR stuff. Your name, sir?
Hello?
Your name? Your name?
Joe Walker, Your Honor.
Mr. Walker, you're here today for two things. First of all, you're arrested for a charge of battery, domestic violence, and also possession of cannabis. I have reviewed the charging affidavit. I do find sufficient probable cause. Do you live at the Grandola Drive address?
Yes, sir.
And does Miss Florence live there also?
Yes, we're married.
Okay. Well, that's going to be a problem. Do you have somewhere else you could live on the short term?
Yes.
A friend or a relative or something? You do?
Yes, sir.
All right, good. Okay, I'll set bond the amount of $500 on the battery, domestic violence, $100 on the possession of cannabis. And conditions of the bond be that you have no contact with Miss Florence. And that, yes? Is she here?
No, she's not.
Oh, no, okay. You have no contact with Miss Florence and that you not return to the Grandola Drive address to reside. You have to have somewhere else to live. Now, you can go back there one time with law enforcement so that you can get your personal items or anything that you may need at the house, okay? But you got to call law enforcement to go with you, all right? Okay. While you're on bond, no drugs, no alcohol, no guns or weapons, okay? Thank you. Your name, sir?
Regine Blair, sir.
What happened to Acevedo?
Mental health, Your Honor.
Mental health. And reset him. It's excellent. All All right, Mr. Blair, you're here today because you're arrested on a charge of possession of cocaine, possession of drug paraphernalia. I have read the charging affidavit. I do find sufficient probable cause. Bond will be set in the amount of $1,000 on the possession of cocaine and $100 on the possession of drug paraphernalia. You're out on bond currently on a possession of a controlled substance, possession of drug paraphernalia, possession of methamphetamine, and two different petty theft charges. And are these warrants too? Oh yeah. And there's also a arrest warrant for the charge of petty theft in the amount of $1,000. And so the bond on that one, on that petty theft, is $1,000. As to the other charges, State, do you want to be heard or?
Yes, Your Honor. The state would ask that you would revoke bond on the other charges, as they are also drug related and in violation of his release conditions.
Let me take a look and see when did this petty theft allegedly occur? February. So this one's been floating around. All right, as to the possession of controlled substance, possession of drug paraphernalia, possession of methamphetamine, the felony case, when revoke bond, there'll be no bond. And then in the petty theft cases, I will revoke those bonds also, and no bond. I'll appoint a public defender to represent you in those cases.
Just to be clear, Your Honor, you revoked on all the cases?
Yeah, on all of them.
This case, the bond stay.
Yeah, those bonds I stayed, yeah. All right, thank you. Your name, sir?
Ernesto Bonilla.
Mr. Bonilla, you're here today because the state of Florida, you were arrested on a charge of aggravated assault with a firearm. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. And do you have any reason to have any contact with your friend Michael or Michael Cologne?
No, sir.
All right. Okay, I'll set bond amount of $2,500 and require that you have no contact with Michael Cologne.
Yes, sir.
No guns, no alcohol, no drugs, no weapons.
Yes, sir. Thank you.
I'll appoint a public defender for you as well.
Yes, sir. Thank you.
Alrighty. Your name, sir?
Jamie Copeland.
All right, Mr. Copeland, you're here today for two things. First of all, you're arrested on a charge of possession of fentanyl. There is a bond of $1,000 on that, and I will appoint a public defender to represent you. In addition, you were picked up on a contempt order, contempt of court in a civil case that had looks like a $3,000 purge on it or bond.
Yeah,
But we're releasing you. But on that case, you're going to be released on your own recognizance. Okay, so that you don't have to bond or anything on that one.
All right.
It's being set for there'll be a hearing on July the 6th of this year. Okay, and you'll get notice of that. All right, I'm signing the notice now. It'll be at 11 o'clock in the morning. And you need to return to court for that hearing. Now,
Hey, listen.
actually, you don't have to come to court. It's going to be a telephone hearing.
Yeah, I don't have no way of getting in touch with him. The reason that bench warrant was is I was burying my baby in St. Pete. You know what I'm saying? I was in Aspire. I was in Lakeside.
I'm just telling you. Okay, there's going to be a hearing on July 6th. It won't be physical. In other words, you won't have to be here, but there's a phone number that's going to be attached to the order that you get, and you call that number on July 6th, and you can appear telephonically, and then you can discuss your case with them. Okay?
All right.
All right, but you'll be released on this one. There's a $1,000 bond on the other one.
All right.
Yeah.
For the child abuse, not qualified for based on pretrial release.
It's an RR.
So you want to just go ahead and RR.
Yeah.
Okay, you just put it on the record.
Okay.
That's the case number that you're going to
All right, and that's 2020 CF 6433AO, the child abuse case. Apparently, and I assume that they're just saying he doesn't qualify for PTR because of the charge. And so, based upon that, then he would qualify. Otherwise, I'll release him on his own recognizance with the same conditions that we imposed before. So, RR with PTR conditions and everything that was pronounced. Okay, come forward. Your name, sir?
Brian Delgado.
What happened to Jerry Daniels?
Behavior.
Behavior. Reset him. What do you want? What is that?
means the COs didn't have a good time with him.
Do you want to waive or?
We give him one more chance.
All right. We'll give him one more chance.
And the next case, Wade
Yes.
Eubanks, he refused? Or did I skip someone?
I think you skipped because we got Mr. Delgado.
Yes.
Eubanks is next. Yep. Okay. All right, Mr. Delgado, you're here today because you were arrested on a charge of possession of hydrocannabinoids and driving while license suspended. I have reviewed the arrest affidavit that was attached to the warrant. I do find that there was probable cause. There's a bond amount of $3,500 on the first count, the possession of tetrahydrocannabinoids, and $500 on the driving while license suspended. I will appoint a public defender to represent you. And then Eubanks, yeah.
With Delgado, he has an open case of Osceola.
Okay. I'll just take no action on that. We don't have that. I don't have that case number anyways.
I have a lawyer, Judge, already.
Okay. I'm not taking any action. So if you're out on bond, then you'll stay out on bond on that. Don't worry about it. Yep. Stay the bond. Yeah. Do you have a case number on that Osceola case just for the record?
Yes, it's case number 2020 CT 000841. It's a DUI case. You're welcome.
And Mr. Eubanks, did you say what was happening with him?
He refused, Your Honor.
Refused. Okay. And then I have Ricky Galmore. Oh, there he is. All right, Mr. Galmore. You're here today because you're arrested on charge of possession of cocaine, possession of cannabis, and driving while license suspended. I have reviewed the charging affidavit. I do find sufficient probable cause. Set bond on the cocaine charge. What's the cocaine? Hold on just a second. 11 rocks.
3.7 grams.
All right. As to the cocaine, I was set bond the amount of $5,000. Possession of cannabis, $100 in the driving license suspended, $100. I'll leave the driving license suspended bond in place. I'll take no action on that, and I appoint a public defender on the new cases for you. Okay.
Yes, sir.
Your name, ma'am?
Daphne Gardner.
All right, Ms. Gardner, you're here today because you're arrested on a charge of grand theft motor vehicle and possession of methamphetamine. I have reviewed the charging affidavit. I do find sufficient probable cause. Set bond amount of $1,000 on the grand theft and $150 on the possession of methamphetamine, and I will appoint a public defender to represent you. Thank you. Your name, sir?
Donald Hobson.
Mr. Hobson, you're here today because you're arrested on arrest warrant capias for failing to appear on dealing in stolen property times 2, a burglary of a conveyance, a receiving money from a pawnbroker, and a petty theft. Your court date was March the 10th. You failed to appear for March 10th. So he does have an attorney. You have a private attorney in the case?
No, sir.
Did you have one in the past? Or did you have an appointed attorney? You must have had something. You had pretrial set. You didn't have. You were going to pretrial by yourself? Oh, that's right. He does RCC. You had an RCC. You had a appointed conflict lawyer. Did you ever see him?
No, sir.
Do we know what the bonds were before? I'm gonna risk. Who's Division 19? She won't be mad at me. I'm gonna set bonds in this. It was close to the end, anyways. So on the dealing in stolen property, count 1, set bond amount of $1,500. Dealing stolen property, count 2, $1,500. Burglary of conveyance. Actually, make that $1,500 100, 1,500 for the Burley conveyance, 100 and 100. So I'm going to set bonds for you on that.
Thank you, sir.
And I think that you already have an appointed attorney. From what we can see, you do. So you may want to, if you bond out, contact the conflict counsel office.
He doesn't have, he's a private off the list.
Oh, yeah. Oh, okay.
Phone number's on the clerk's website. So if you
All right. So actually, it's even you're 3 steps past. So there must have been a whole bunch of co-defendants. His name is Jason Bankowitz. That's a private lawyer that's been appointed to represent you.
Okay.
So if you look him up, you'll be able to find his number. I'm sure he's on the internet. Okay?
Thank you.
Bankowitz. All right.
The next person, Odie Harris, Your Honor, is at hospital.
Yeah, I'm not surprised. I signed a search warrant on that case. Yeah. Yeah. Yeah, that's going to be mental health. Okay. Antonio Hernandez.
Yes, sir.
All right. You're here today for a number of things. First of all, you're arrested on a charge of from a arrest warrant for fleeing and attempting to elude, possession of cocaine, and possession of drug paraphernalia. Bonds on that are the fleeing attempting to elude $2,500, $1,000 on the cocaine, and $1,000 on the drug paraphernalia. And then there is also now this is a separate case, right?
He was arrested on a fleeing and eluding warrant, and he's accused of fleeing while they were challenging probable cause on the fleeing because you can't identify.
Well, that was my question. I know that you can have that a bicycle is. I think that's what is in the arrest warrant was a bicycle, or no, it was a BMW. I know a bicycle can be a vehicle for DUI purposes, but I don't know.
Don't think the statute defines motor vehicle, but other define motor vehicle. He self-propelled vehicle, not ours.
Yeah, I mean, when I saw it, when I read it, I thought that's a resisting without violence is what we almost always see. Not this. Yeah. So I'm inclined to agree with you on that one. On the first one, 2,500, 1,000, 1,000. Yeah, we're just leaving that. Well, 316-1935 says any vehicle.
That's what I see as well.
It doesn't define vehicle in the statute, and pursuant to the interpret that in favor. Given the ambiguity.
I mean, motor vehicle and vehicle are very different. I don't think we'll let it do the couple of.
Well, no, it does. The definition statute, the definitional portion of 316 has vehicle. It's under section 99. Every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except personal delivery devices, mobile carriers, and devices used exclusively upon stationary rails or tracks. Yeah, so I think it does. That's 316 and it's 316, so that's in the DUI statute. All right. So I do find that there is PC for the fleeing attempts included on the new case. We'll set bond. I'll set bond $1,000 on that one and $100 on the resisting without violence charge in the other case. And we will appoint a public defender for you on the new case as well. Okay?
Okay, sir. On the arrest warrant, I never got documentation on those charges. I only got the office. Only got the office.
You just got the warrant. You didn't get the actual affidavit.
Yes, sir.
Yeah, your attorney will have a copy of that, and they can go over with you. I'll just tell you. I mean, basically, the allegation was that you were driving a BMW, and then that's where it all went from there.
And then they try to say there was paraphernalia and cocaine in the vehicle,
maybe,
which
yeah.
there wasn't.
Yeah, maybe it might have been in the car. I don't know, but that was Judge Whitehead signed that. Okay, but you have a public defender; they'll get all that stuff and they can show it to you.
Yes, sir.
All right?
Thank you.
All right. Good luck. Your name, sir?
Martin Lyons, sir.
Mr. Lyons, you're here today because you're arrested on a charge of neglect of child, destruction of evidence, and possession of cocaine. I have read the charging affidavit, and I do find that there's sufficient probable cause. Bonds will be set in $1,000 on count one, neglect of child, $150 destruction of evidence, and $150 on possession of cocaine. And you are, and I will appoint a public defender for you on that case.
Sir, I have a private attorney I can use to represent me on this, if you don't mind. I mean,
Okay, that's fine. That's no problem. Then I want to appoint public defender. They just need to file their notice of appearance.
Okay.
And then you're also currently out on possession of cocaine and possession of drug paraphernalia, and you're set for July 14th.
Yes, sir.
All right, I'll take no action. I'll leave that.
Thank you so much, sir. I really appreciate it, Your Honor.
Well, appreciate it by not using cocaine.
Exactly. Thank
really,
you.
that's what you should show some respect for your children to do that. But
Yes.
whatever.
Yeah. So,
All right. Good luck.
Thank you.
Good luck. Your name, ma'am?
Yes, sir.
Brittany Miller?
Yes, sir.
All right. You're here today because you're arrested on a charge of possession of cocaine, possession of heroin, and introducing contraband into a state facility. I've read the charging affidavit. You find sufficient probable cause. On the possession of heroin, I'll stay the bond at $1,000. Possession of cocaine will be $100, and introduction of contraband $100. Yeah. I reduced the cocaine to 100 and left the heroin at 1,000 and $100 on the contraband. All right, no action on the other bond case. Your name, sir?
Craig Moore.
Mr. Moore, you're here today because you're arrested on a charge of grand theft motor vehicle. I have read the charging affidavit, and I do find sufficient probable cause. I set bond amount of $1,000, and I will appoint a public defender to represent you.
Thank you.
All right. Your name, sir?
Angel Sanchez, sir.
Mr. Sanchez, you're here today because you're arrested on a charge of possession of a controlled substance without a prescription. I have read the charging affidavit, and I do find sufficient probable cause set bond amount of $1,000, and I will appoint a public defender to represent you.
There's a second case, Your Honor.
Oh, there's a second case. Hang on. And that is the driving license suspended charge. I do find sufficient probable cause set bond amount of $500, and a public defender will be appointed on that one as well.
So for total, my bond is what, 1,500?
Yep, 1,500.
And then I could have somebody bomb me out right now.
Your Honor, he's currently on state probation, so he has a violent felony offender of special concerns detainer, so he won't be released today.
There's your answer.
So how long? How much more longer do I have to wait?
The possession and the
I've been here
500.
2 days already, though.
Step that way.
Well, thank you. Your name, sir?
Kenneth A. Sandage.
Mr. Sandage, you're here today because you're arrested on a charge of possession of fentanyl and possession of drug paraphernalia. I do find sufficient probable cause based on my review of the charging affidavit. Set bond amount of $1,000 for the possession of fentanyl and $100 for the possession of drug paraphernalia. And I will appoint a public defender to represent you.
There's no chance of getting out of here besides bond, pre-trial, so I don't lose my job.
Nope, you don't qualify, unfortunately. Your name, sir?
Thomas Holden Scott.
All right, Mr. Scott, you're here because you were arrested on a arrest warrant for a charge of grand theft, third degree. The bond is $2,500. And I don't, when did, oh, and this allegedly occurred on April 9th. You're also currently out on bond for a charge of petty theft in one case, and then a second petty theft, and then uttering of forged bills. On all of those, I'm going to revoke those bonds and set no bond.
No bond?
Yep, on the old cases that you're out on bond on.
So what does that mean?
No bond.
That means there's no bond on those. You violated your conditions of bond. I revoked them.
This way, street.
Your name, sir?
Yes,
Your name?
Jerome Streeter.
Mr. Streeter, you're here today because you were arrested on charge of battery with 2 priors. I have read the charging affidavit. I do find sufficient probable cause. Bond is set in the amount of $1,000. If you do bond out, then you're not to have any contact with. Hang on just a sec. You're not to have any contact with Veronica King. And you are also out on bond on an open container case. I will leave that in place. So you don't have to worry. Or it looks like you got released on that. Yeah, there's not a bond, but I won't change that. So you just have the bond of $1,000 on the battery charge. I will appoint a public defender to represent you. All righty. Good luck.
That way. The next person is James Anderson, bonded, Your Honor.
All right, James Anderson, bonded. Your name, sir?
Mac Leslie.
What about Anthony Garcia?
I don't have Anthony Garcia.
You have an inmate number?
Oh, what was that?
You have a jail
Oh.
number for Anthony Garcia?
It is 200-1212. Oh, excuse me, 162. 200-12162.
Bonded, Your Honor.
Thank you.
You're welcome.
Your name, sir?
Mac Leslie.
There we go. Gotcha. You're here today because you're arrested on a charge of driving while license suspended. I have reviewed the charging affidavit. It does appear that there is probable cause. Bond is set in the amount of $500. I'll appoint a public defender to represent you.
Thanks.
Call him Ms. Jackson.
Jeremy Sheets.
I'm sorry, what's the name, Your Honor?
Sheets. Kenneth Sheets is the next one I have.
What's the jail number, Your Honor?
200-12169.
Bonded?
You probably bond. Yeah, it was only $100. Okay. Thank you. There you go. Okay, your name, ma'am?
Shamira Jackson.
And what about, let's see, I had Nestor Eduardo Calderon Ramirez.
Refuse, Your Honor.
Refused. Want to wave on him?
Yeah, go ahead.
All right. I did find sufficient probable cause in the case. Set bond of $500 on the battery, $100 on disorderly conduct. If he does bond out, he's not to return to the 7-Eleven at 4690 South Kirkman Road or have contact with Bianca Flores.
Your Honor, the next person, John Doe, is mental health.
Okay. Hey, what did I just give you? Oh, I had this sheet out of it. Okay, there we go. All right, great. And John Doe, you said is mental health.
Yes, Your
Alrighty.
Honor.
Your name, ma'am?
Shamira Jackson.
Oh, that's right. You told me that a couple of times. But I have Derek January.
Mental health, Your Honor.
Michael Lazuski.
He's next after Miss Jackson.
Okay. Do you have that one? I don't have her. That's what I.
Oh, we should go.
Did I? Oh, you know what? That was my fault. That's all right. Hold on. Trying to move too quick. I see her sheet. All right, ma'am. Miss Jackson, you're here today because you're arrested on charge of trespass on property after warning. I have reviewed the charging affidavit. I do find sufficient probable cause. Set bond in the amount of $500. If you do bond out, you're not to return to the Dollar General store at 928 South Ivy Lane. Okay,
Judge.
Public Defender will- Yep.
Judge, I was hoping if I could get this resolved today.
State have an offer.
Yes, Your Honor. After looking over her history, she has 11 prior trespasses that were all adjudicated. As of right now, the state's offer is an adjudication, 10 days OCJ, no return and court costs.
The offer is adjudication 10 days. And I guess you probably have 2 at this point, yesterday and today, if you were arrested last night.
Okay. Thank you.
Do you want to do that, or you want to go ahead and just want me to set the bond?
I'll do.
What's your decision?
I'll just set a bond.
Okay. Bond set at $500. All right. Mr. Lazuski.
Yes, sir.
Fine, got to you. All right. You're here today because you were arrested on charge of disorderly conduct. And I do find sufficient probable cause. Did you want to try to resolve this today?
I would like to, yes, Your Honor.
Time served, adjudication.
Rouse. Come on, man. Come on. Right there.
Your Honor, yes, I had an adjudication and no return of court costs.
All right. So if you want to enter a plea of no contest, it would be an adjudication of guilt, time served, no return to the wing shack, and there'd be court costs and a cost of prosecution, which total of $273, which I'd have you either pay in 180 days or I'd have you pay with a payment plan starting in August. Is that what you wish to do?
180 days is fine, Your Honor.
All right. So you want to plead no contest then,
Yes,
is that right?
no contest.
All right. Are you under the influence of any drugs or alcohol today?
No, Your Honor.
Have you suffered from or been treated for any mental illness in the past?
No, Your Honor.
They gave you a plea form. You read over that. Did you understand all the rights on the form?
Yes, Your Honor.
Do you have any questions about anything on that form?
No, Your Honor.
You understand that this is punishable by a maximum of up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, Your Honor.
You understand? All right. I do find sufficient factual basis to accept your plea. I'll accept your plea of no contest. I'll judge you guilty of the charge of disorderly conduct. You'll be sentenced to the time you've served. I'll impose court costs and a $50 cost of prosecution, and we'll have you pay that in 180 days.
Thank you, Your
Okay?
Honor.
You'll be released. You're all set.
Thank you, Your Honor.
You're welcome. Your name, ma'am?
Mills.
Is that Gentarica? Is that right?
Centerica.
Oh, you know, they have it as a G on the paper, but I see it's supposed to be a C. Centuria Mills. All right, ma'am. You're here today because you were arrested on a charge of petty theft. I do find sufficient probable cause. Set bond in the amount of $500.
She's undergoing competency proceedings in her out on bond case, so I just didn't want her.
She also was just recently involuntary placed, so we don't know.
Okay. All right. I'll appoint a public defender for you too. Apparently, they're already representing you, so they'll help you out with this case too. And I'm going to stay. I'll stay the other.
Do I have a bond, sir?
Yes, you do. It's $500. It's $500.
Can I have court costs and be released? And pay like $500 when I get released? Can I be released at this time and point? Because I don't know if I don't have.
They're telling me that you can't enter a plea on this because of your other case, because you have another case pending. That's the only reason. But you can talk to your lawyer about that. They may talk to you about potentially working it out. Okay.
Okay.
No action.
All righty.
So no action on the out on bond.
Yeah, no action. Because I think it's probably ROR for competency. I don't know. Your name, sir?
Robert Rouse, sir.
All right, Mr. Rouse, you're here today because you're arrested on a charge of resisting a merchant and petty theft. I have read the charging affidavit. I do find sufficient probable cause on those. I'll set bond the amount of $500 on the resisting a merchant and $100 on the petty theft. Now, you also were out on bond on a petty theft with 2 priors and resisting an officer without violence. I'll revoke that bond and set no bond. Appoint a public defender to represent you on your new case.
Okay.
Bonds were stayed on this one.
Yeah. And then revoke on the old case. Your name, sir?
Yes.
Your name?
David Stager.
Mr. Stager, you're here because you were arrested on a charge of resisting an officer without violence. I have read the charging affidavit. I do find sufficient probable cause to set bond the amount of $500. And did you want to have a public defender appointed?
I was offered a plea.
Oh, you were? What was the offer? Just a plea case?
Well, that.
They give them.
Well, this was given to me. Actually,
okay. All right. Do you want to resolve the case?
What?
I'll see if the state has an offer for you.
Sure.
If you would like to resolve. Okay, let's find out. She's looking at it right now.
Your Honor, as of right now, it's an adjudication in 10 days.
The offer is adjudication in 10 days.
Okay.
And you have, 2 days credit? Or I'll set a bond of $500. You can potentially bond out.
Fine.
Is that what you want to do?
Yes.
You want to just want to bond out? All right. I'll set a bond of $500 and I'll appoint a public defender also to represent you.
Okay.
Okay. All righty, good. Thank you. All right. Your name, sir?
Renard Jean.
All right, Mr. Jean, you're here because you were arrested on a warrant out of Hendry County.
Yes, sir.
For the charge of possession of cannabis. There is no bond on that currently. I will tell you that what we are doing, because they're not transporting anybody to other counties, our judge here will contact Hendry County and find out from the judge if they wish to set a bond in that. So we will bring you back after that contact and let you know what the judge in Hendry County said. If they set a bond, when you come back, we'll tell you what that is. If they did not, then we'll just have to wait until we can actually get you transported to Hendry. Okay?
Yes, sir. Second
All right,
question.
good luck. And also, you will have a public defender, a local public defender appointed to try to work with you on that. They'll potentially try to see what they can do to figure it out. Okay?
Yes, sir.
Well, what's your question?
I had a letter from the court of Hendry County. That's why I was going out south. That states that I have till July 22nd to finish all my recommendations, or then a arrest warrant will be put out on me.
Well, something happened, got crossed up because that warrant went out before then. Okay, but hold on. If you have that letter, a public defender will probably come speak with you, and you can show that to them, and maybe they can use that to talk to the judge. Okay?
Yes, sir.
All right. Thank you.
No problem.
Thanks.
Reset, or will it be
It's not rescheduled at this point. They'll wait, and then once the judge speaks to them, then they'll give us a date. He's just being held. Yeah. Your name, sir? Come on.
Charles Smith.
What about Paul Clark? Is that still mental health?
Mental health, Judge.
Christopher Clements, still mental health?
Yes, sir.
Yeah, let me see. Yeah, you know what? On that last one? Yeah, on I'm going to waive on Mr. Clark, set bond the amount of $250 on the disorderly. And on Mr. Clements, I'll waive him on the trespass, set bond amount of $250. I'll change that to $250. All right.
Your Honor, on Mr. Clements, were you going to take action on his out on bond cases?
No, we'll leave those in place.
Okay, thanks.
All right. And your name, I'm sorry.
Charles Smith.
Mr. Haddon, is that still mental health?
He refused, Your Honor.
Okay.
We can waive Mr. Haddon.
All right. They're going to waive. I'll set bond the amount of $500 on Mr. Haddon's case.
No action on the out on bond.
And no action on the out of bond. Jane Doe, still mental health?
She is, Your Honor.
I want to reset that one. They're in order.
Did you say here that
I left it at 500. Okay. Because he has other ones. And I want to reset the Jane Doe. Okay, all right. And then we had Charles Smith. There we go.
I had Lycans next. Did we address her, or is that Jane Doe?
That's a name now. We got a name for her.
Okay.
She's 7.
So reset.
She was one that was swimming in the fountain at Central Park in Winter Park. Your name, sir, is Charles Smith. Is that right?
Yes, sir.
Okay. And what were we waiting for?
This was a reset from yesterday regarding what the bills were. I did obtain an amended affidavit from the officer.
Okay. Yep.
I've already provided a copy to
Yes, Your Honor, we stipulate that there's probable cause.
All right. So remember yesterday, Mr. Smith, we had you here, and the question was whether or not they could identify the pills or not.
Yes.
They have filed a amended affidavit, so it is there. So what I'll do is I will set the bond at $1,000 and appoint a public defender to represent you. Okay.
The bond is too low, high for me to bond out on.
Contact your attorney, and they can file a bond motion at that point. All right. Because we are doing those. Those are still going on a regular basis. All right. Good luck. Your name, sir?
Lester Starling, sir.
Mr. Starling, you're here today because you were arrested on a charge of two things. There's a possession of cannabis, and I have read the charging affidavit. You find sufficient probable cause, set bond of $100. I'll change the bond to $100. You're also arrested on a warrant for violation of probation, or there's a violation of your probation, and there's no bond on that. I'll appoint a public defender on both those cases.
Sir.
Yep.
On the probation, that's my drug court probation. Will they just ship everything in front of drug court judge?
Most likely.
They probably will. They should. If they don't automatically, if another public defender sees you on the possession of cannabis case, then tell them that you have that case, and then they'll make sure that happens so it all goes together, right? Because it should definitely be all together, and there's a good chance it'll go right away, but just in case. Okay? All right. Your name, sir?
Keon Williams, sir.
All right, Mr. Williams, you're here for two things. First of all, you're here on a violation of probation.
Excuse me, sir. I was never on probation.
It might be a
Or it could be, it might be a parole. I think it's parole because it's correction. It's state corrections. But you also have an arrest on a new charge of possession of methamphetamine and possession of synthetic cannabinoids. I have reviewed the charging affidavit. I do find sufficient probable cause on those. Bond will be set at $1,500 on the possession of ecstasy and $150 on the synthetic cannabinoids. Currently, there's no bond on the parole violation.
Excuse me, sir. At the moment of time, they actually have me booked under the wrong name.
Well, as far as that goes, I've just been told we don't even IAA you on that anyways. So on the parole thing, that's something separate. So really, I have to worry about is the what I said on the bonds. Okay.
What I'm saying is, like, on the bonds, like I could really care less, but on the probation, I don't think they understand that they have the wrong guy. Like, I don't know if they understand that they booked me under the wrong person.
Well, the name is pretty distinctive. It's not like it's Joe Smith, so they're gonna have to figure that out. The paperwork has a picture that looks kind of like you.
Yeah, it's a VOP. I just looked it up.
It is a VOP? Where is it from? Here?
It's here in front of Judge Young in Division 14.
So it's you had no case in front of Judge Young?
No, sir.
Well.
He just pled on May 4th. But, I mean.
Oh, wait a second. Hold on.
So I've got the case pulled up here on clerks.
So he pled, you're on probation? You pled on May 4th?
No, I don't remember that, sir.
All right, well, we're done. Next. He doesn't remember. You don't remember May 4th? Okay.
Haven't been in jail since May.
That's not what you need to do. That was a bad move, my friend. We'll see you tomorrow on that charge. Just swing at him. Because he just tried to move him away because we were done. Yeah. Well, now he definitely violated. Now he has violated probation because that charge is going to violate his probation. Sorry about that. I should have had him moved along on before. That's my fault. I let him engage too long.
He's okay.
All right. Okay, Larry Allen.
Yes, sir.
Okay, Mr. Allen, you're here because you're arrested on an open container charge. Did you want to resolve that today?
Yes, sir.
If you want a plea, I'll give you time served and court costs.
Yes, sir.
Is that what you want to do? All right. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
You understand all the rights you're giving up by entering your plea today? Saw a plea form?
Yes, sir.
Do you have any questions about those rights?
No, sir.
You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result and potentially result in deportation if you're not a citizen.
Yes, sir.
I know you are, but I have to tell you that. All right. I do find sufficient factual basis. I'll withhold adjudication and post.
Your Honor, I'd ask for an adjudication. He has prior alcohol beverages, open containers, several of them.
You know, if it were me walking down the street, it wouldn't even be arrested. I'm going to withhold adjudication. Court costs and a $50 cost of prosecution to the state. Do you want to pay that in, it's like $273, or actually it's what, $203? $223. Did you want to pay that in 180 days, or would you like a payment plan?
Payment plan.
Can you do $20 a month?
Yes, sir.
First payment due by the 17th of August and every 30 days or after.
Yes.
Okay?
Yes, sir.
You'll be released. All righty. Your name, sir?
Sir, I'm Pedro Cotterell.
Good afternoon. Good afternoon, Mr. Cotterell. You're here today because you were arrested on a camping charge. You were sleeping in Lake Dot Park. Did you want to resolve that?
Yes, sir.
All right. If you want to enter a plea of no contest, I'll. What is it, a withhold or adjudication? I'll ask you. Yeah, we could withhold on that. All right. So if you want to enter a plea, it'll be withhold adjudication, time served, and court costs. It'll be 223. Is that what you want to do? And I can give you a payment plan, or I can have you pay it within 180 days. The 223.
Sure. Would I be released?
Yeah.
All right. Yeah.
You'll be out today.
All right. Sure. I can do that.
So you want to enter a plea of no contest? Is that right?
Yes, sir. The payment plan. Could we do it monthly?
Yeah. We'll talk about that when we get to the end. So, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
Now, you read over a plea form. Did you understand all the rights on that? And do you have any questions about those rights?
No, sir.
All right. You're saying you understand all the rights you're giving up by entering your plea of no contest here today?
Yes, sir.
All right. You also understand that the maximum penalty of this is up to 60 days in jail, up to a $500 fine, and that the entry of your plea might result in deportation if you're not a citizen.
Yes, sir.
Understand? All right. I do find sufficient factual basis. I'll withhold adjudication, sentence you to time served and court costs to be a total of $223. Now, I'll give you a payment plan. Can you afford $20 a month?
Yes, sir.
First payment won't be due until December 17th and every 30 days afterwards. So every 30 days, you just pay the $20. Okay?
All right. Thank you.
All right. You'll be released. Thank you.
Mr. Hostetler's mental health, Your Honor.
All right. Your name, sir?
Darius Antonio Hilton, sir.
Mr. Hilton, you're here today because you were arrested on an open container charge. I have reviewed the charging affidavit. I do find sufficient probable cause. Did you want to resolve your case today?
Yes, sir, Your Honor.
All right. So you want to enter a plea of no contest. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
You read over a plea form, understood all the rights on that form?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
You understand that this is punishable by a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
All right. I do find sufficient factual basis to accept your plea. I'll withhold adjudication, send you to time served, plus court costs. It'll be a total of $223. Did you want to pay that in 180 days, or would you like a payment plan?
I'd like to get on the payment plan.
Can you afford $20 a month?
Yes, sir.
Your first payment will be due by August the 17th, and every 30 days or after till it's paid in full.
Yes,
Okay.
sir.
All right, good luck. You're all set. Your name, sir?
Taurus Royal.
What happened to Ray Lamar?
He's mental health, Judge.
He's incompetent. All right, I figured he probably was. All right, they're going to waive. I'll just step on in the amount of $250 on that, and I'll stay the other one since he's doing mental health stuff.
Book 250 on both.
Is there two?
There's 4 out on bond cases.
Yeah. So no action on the add-ons.
Disorderly conduct and state misdemeanor.
Oh, okay.
This is from Mr. Lamar. They're both 250.
I only had one. Did you have another one? Is that it there? Yeah, that's Mr. Hilton. Oh yeah, here it is. Found it. Yeah, 250 on both. Okay. All right, and you were Mr. Royal, is that right?
Yes, sir.
All right, Mr. Royal, you're here today because you were arrested for being in the park after hours. Did you want to resolve that case today?
Yes, sir.
Do you want to enter a plea of no contest, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
They gave you a plea form. You read over that. Did you understand all the rights on that form?
Without my glasses, sir, I can't read it.
All right. Well, you understand you have the right to have a trial. You have the right to have an attorney represent you. You have your right to question any witnesses that may be brought against you. You have a right to have witnesses brought to your defense, and you have a right to require the state to prove your case beyond the exclusion of all reasonable doubt. You understand that?
Yes, sir.
Any questions about any of that?
No, sir.
All right. Finally, understand that this is punishable by a maximum of up to 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Yes, sir.
All right. I do find sufficient factual basis. I'll withhold adjudication. Sentence you to the time you've served. There'll be court costs in the amount of $223. Did you want to pay that in 90 days, or excuse me, 180 days, or would you like a payment plan of $20 a month? It's $223.
$20 a month.
Yep.
What if I don't have? I'm not able to pay it. I had to serve some time, 180 days.
No, No. If you can't make the payment, though, they could either suspend your driver's license, or if you want to write me a letter, my name will be on the paperwork you get every day. You can always write me a letter and say, Judge, I can't pay that now, and I can try to change the dates. I can help you out with that.
Okay.
If you want to go payment plan, or you can do 180 days, same thing. If you don't think you're gonna get it paid, you can always write me a letter.
Okay. Yeah.
Which one you want to do?
Well, I don't think I can pay. I don't have a job. I won't be able to.
So which one do you want to try to see that you can live up to? The 180 or the payment plan?
The 180.
180 days to pay it off, and then if you can't, write me a letter.
Okay.
That means February 1st. It has to be paid by February 1st next year. If you can't, then you can always write me a letter.
Yeah.
Okay?
Okay.
All right. That'll work then. Thank you.
Yeah.
All right. Your name, sir?
Elwood Smith.
All right, Mr. Smith, you're here today because you were arrested on a charge of open container. I have reviewed the charging affidavit. I do find sufficient probable cause. And I would set bond in the amount of $250. Do you want to resolve your case today?
Yes, sir.
All right, so you want to enter a plea of no contest to that? Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
You read over a plea form. Did you understand all the rights on that?
Yes, sir.
You have any questions about any of those rights on that form?
No, sir.
You understand that this is punishable by a maximum of up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
I do find sufficient factual basis to accept your plea. I'll withhold adjudication, impose court costs. You're sentenced the time you've served in the Orange County Jail. It'll be a court cost in a total of $223. Did you want to pay that in 180 days, or February 1st of 2021, or would you like a payment plan of $20 a month?
The 180.
All All right, so pay that within 180 days and must be paid in full by February the 1st of 2021. Okay?
Yes, sir. So that's credit.
Release, you're all set.
That's
What's
credit-
that?
That's credit time served?
Time served, you're done, that's correct.
So I'll go
They'll
home.
process you out now.
Don't ask that question.
I'll go home tonight, right?
Get out.
Yep. Last but not least, Leroy Smith, is that right?
Yes, sir.
All right, Mr. Smith, you're here today because you're arrested on a charge of camping for sleeping in Lake Dot Park. I will set a bond. I do find sufficient probable cause to set bond of $250, but did you want to resolve your case today?
Yes, sir.
If you wish to enter a plea, I'll just withhold adjudication and sentence you the time that you've served. Is that what you wish to do?
Yes, sir.
All right, so you want to enter a plea of no contest, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
They gave you a plea form to read over. Did you understand the rights in that form? And then, or do you have any questions?
No.
You understood
I
all those
understand.
rights?
I understand.
All right.
Yes, sir.
And no questions for me about those rights?
No, sir.
Okay. You understand finally that this is punishable by a maximum of up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
I understand.
I do find sufficient factual basis to accept your plea. I'll withhold adjudication and sentence you to the time that you've served in the Orange County Jail. Impose court costs, a total of $223. You want to pay that in 90 days, or would you like a payment plan of $20 a month? Or, excuse me, 180 days, so it'll be February 1st. Which one would you like?
February the 1st.
All right, pay within 180 days, February 1st, it must be paid in full.
Okay.
And that's it, you're all set.
Thank you, sir.
Thank you. All righty, good luck. Now it's like 2:21, it's almost exactly the same time as yesterday. Was it?
Yeah.
It seemed like it might be more. All right, thanks a lot, you guys. We'll see you tomorrow.
Have a good one. Why do you want to